Brad, you've deposed many an estate planning attorney during the course of your career. How many attorneys have you deposed before?
Probably 20 to 30 estate planning attorneys.
Before you depose an estate planning attorney, what is your process? Do you normally subpoena the file?
We always want to get the file first, because we want to see what we're looking at. And obviously you need the file in order to prepare for the deposition.
What are the key things in an estate planning attorney's file that you were looking for when you were in litigation?
So first of all, we want all the notes. We want the attorney's notes. So if an attorney met with a client and took notes, we want the notes. Sometimes there's an intake sheet where the attorney will meet with the client, and either the attorney or the client will fill out the intake sheet, which shows all of the estate assets, all of the people who are involved, and gives you kind of a general idea of what you're looking at.
Imagine I'm the estate planning attorney and I get subpoenaed. Am I entitled or am I required to turn over my notes because of attorney work product?
Yeah, see, that's a great question. Whenever I, as a litigator, subpoena an estate planning attorney for their file and for their deposition, the first thing that usually happens is there's a fight over attorney-client privilege and work product. So the notes are your work product, and you have to kind of deal with how you're going to negotiate that issue. And that might take court action, or it might just be worked out between the parties.
If I'm an estate planning attorney, what kind of rules of thumb should I have in mind when it comes to privilege about what I can and can't produce?
So the privilege is usually the attorney-client privilege we're talking about. And interestingly, the evidence code has several sections that talk about the attorney-client privilege and how it changes when somebody passes away. Some attorneys are surprised to find out that there are parts of the evidence code that actually say there is no attorney-client privilege when you're dealing with a deceased client in certain situations, like when you're talking about the intent of the decedent, you're talking about competence of the decedent when they sign the documents, even documents that just talk about the validity of real property transfers or other transfers. Again, the attorney-client privilege may not apply at all in those situations. So it's going to take some work to figure out whether the documents in your file would fall under the privilege or not.
So if I'm getting a subpoena asking for my entire file in the course of litigation after my client has died, what should I be thinking of producing and not producing?
So there's a couple different levels you can go. The first level is, which is the safest way to go, is hire a lawyer, which nobody wants to do, and do the research, have that lawyer do the research, preferably a lawyer that's experienced in this area, and have that person look at your file and see, okay, this is privileged, you can withhold that, maybe you should not withhold that, and in the end, you may end up being in court with a judge trying to decide what gets disclosed and what doesn't.
Imagine now we've gotten my file and you're now going to depose me as an estate planning attorney. What should I expect?
Okay, so I have a system that when an estate planner comes in and sits down and I start deposing that person, I have a kind of a checklist I go through. First of all, I want to know all of their vocational experience, what jobs have they had, what's their experience as an estate planner. I want to know what their educational experience is. I want to know if they've testified as an expert in any capacity. I want to know if they've spoken, if they've written in the subject. I want to know everything about that person to know who am I dealing with. Some estate planners, when they did the estate plan in question, they'd done a few estate plans, maybe it was 5 to 10% of their practice. Other estate planners are certified specialists and they've been doing it for 20 years. I want to know who this person is I'm dealing with. So that's number one.
Okay.
Number two is I'm going to go into what happened when this deceased person who was your client came in your door. I want to know every single thing that happened from the time they walked in your door until the time that you never talked to them again, including all correspondence, all conversations, what their intent was, And of course, it depends upon what the case is about, but I get pretty deep into it. My goal, if I'm representing the person that wants to show that the estate plan is no good, my goal is to undermine everything that the estate planner did and to show that it should not be enforced.
Okay, so I'm in my deposition with you. Let's just put me in the deposition chair for this question. How long does it go? What can I expect of the kinds of questions you're going to ask that are going to undermine the estate plan that I put together?
So the first question you said is, how long is it going to go? Usually it's 3 or 4 hours, I would say. Depending on the person taking the deposition, it could be less or more. But the average, I think, is 3 or 4 hours you can expect to spend there. And then what questions am I going to ask? How am I going to try to undermine what you did? I'm going to have looked at all of the documents that you drafted. I'm going to read through them all and see if they're legitimate, not legitimate. Like, I just took a deposition a year ago where the decedent had signed the page on one date, but the notary stamp and certification was on a different date. And there was a third page that had additional information that was a year later. So there was all together in one document. So I got to depose this attorney and basically try to undermine his credibility because he's having his client sign a document on one date, notarization on another date, and then more information from the document on another date. It did not add up. And that particular attorney was not prepared for that, so he really couldn't explain it. And it made him look really bad. So you want to be prepared.
How many, approximately percentage-wise, of the estate planning attorneys you depose are represented by their own counsel?
Very few, actually. They don't want to spend money, estate planners, and I don't blame them. Estate planners are taking off their day, they're taking their time. They do not want to hire a lawyer, so I'd say probably 10%, 1 out of every 10, have their own lawyer.
Do you have any war stories of any times you deposed an estate planning attorney and they should have had counsel?
We just had an attorney that we deposed about 6 months ago because he did estate planning documents for a person who the court had ordered is not allowed to do any estate planning documents. Yet this attorney who knew that order came in and got that person into his office and did all these estate plans that completely changed the estate plan, 100%, shifted it millions and millions of dollars, over 10 million from one person to another. And this person basically, I got to a point where I was questioning him the same way I'd be questioning somebody in a courtroom for contempt, because my plan was to get him held in contempt because when he drafted this particular estate plan, in my view, he had violated court orders. So it can get pretty gnarly, I guess use that word, it can get pretty intense if you're looking at possible contempt jail time for answering the questions wrong. And in that situation, if I was his attorney, I might want to plead the fifth. It can get that bad.